In our second video, we're going to examine Article 1.2, which looks at what happens when parties lose at the United States Supreme Court. The article makes a point of focusing only on cases which arose from state Supreme Courts, which brought to my head that we should probably talk about the nature of the dual hierarchy system of the judiciary in the United States. Um, in order to explain why some cases go back to state Supreme Courts on remand, while other cases go back to federal appellate courts on remand. And that has to do with the nature of judicial federalism and also has to deal with the nature of how states versus the federal government organize the judiciaries. Now understand the court of final resort um, in the United States is the United States Supreme Court. It has jurisdiction over every court within the United States under some circumstances, but each state operates its own judiciary, which has say and jurisdiction over questions which arise under that state's laws. So there exists a dual hierarchy in the United States, with the federal courts as one part of the hierarchy and each of the 50 state courts as another part of the hierarchy. So we like to think of that as a dual hierarchy. We'll take Texas, for example. So in Texas, there are trial level courts which deal with the initial determination of matters. So these trial courts are what we call courts of records, in that they establish the facts for cases going forward. If an individual who loses at the trial court wishes to appeal his case to an intermediate appellate court, they must argue not that in most cases, not that the facts were determined incorrectly, but that a question of law, was applied incorrectly in their case. And an intermediate appellate court within the state of Texas will make that determination. If an individual loses at the intermediate appellate court, they can then appeal to the Texas Supreme Court or, because Texas is interesting, the Texas Court of Criminal Appeals. Texas is one of two states, Texas and Oklahoma, that have two state Supreme Courts, or what we call two state high courts. And in both states, Texas and Oklahoma, there is one for civil matters and one for criminal matters. But we'll just deal as though only the Texas Supreme Court exists, as though we're dealing with a civil case. When the Texas Supreme Court makes a decision, the decision that they are making is based upon Texas law. So either the Texas Constitution or Texas statute. Now, the losing party at the Texas Supreme Court can appeal to the United States Supreme Court if there exists a question of federal law or federal constitutionality. Because we know in many circumstances, the United States Constitution will trump state-based law or states' constitutions. So the circumstance by which you get to the United States Supreme Court is you either go through your state's judicial hierarchy and then have a federal question which the United States Supreme Court can settle, or you go through the federal hierarchy, which means a federal trial court, a federal court of appeals, and then the United States Supreme Court. In the article in 1.2, what happens is the individuals appeal through the state judicial system, then appeal to the United States Supreme Court, lose at the United States Supreme Court, and are remanded back to the state Supreme Court for a decision. So what does that process of appealing look like? Well, the method by which you appeal from both the federal hierarchy and also the state hierarchy is known as a writ of certiorari. A writ of certiorari is the formal process by which you ask the United States Supreme Court to hear your case. What you are asking the court to do is to certify the lower court's record and review it. So it's basically calling up the case from the lower court. So this is the process by which cases get from the federal appellate courts and the state Supreme Courts to the United States Supreme Court. But remember that in the state context, there has to be a federal question because the United States Supreme Court cannot review determinations of state law or the state constitution unless there exists a federal question that may run in conflict with the state law or state constitution. In particular, in this article, looks at what happens when you lose at the United States Supreme Court. Well, when you lose at the United States Supreme Court, what you're losing is on a federal question. And then that case can get remanded back to the state court for the state to rule again in light of the United States Supreme Court's new precedent. What Dr. Price finds is that the overwhelming majority of these cases that lose at the United States Supreme Court and are remanded back to the state courts is that the parties that have lost change their argument. So that while at the United States Supreme Court, they're arguing that some part of the Constitution is controlling and therefore invalidates what the state has done or validates what the state has done. Once they lose on that federal question and get back to the state courts, the losing parties change their argument and attempt to win their case on the base of some state constitutional interpretation. And the reason that they can do that is that state constitutions can go above and beyond the protections that exist within the federal constitution. So that's to say that states can protect rights to a significantly larger degree than the federal constitution might. Some good examples of this are, for example, the right to privacy. The right to privacy does not exist within the federal constitution, at least textually. It's not there as written down. But numerous state constitutions have very explicit protections towards the right to privacy. And so the states can go above and beyond. Think of the federal constitution, the United States Constitution, as sort of the ground level. And state constitutions can build up above it. So when these individuals, these losing parties at the United States Supreme Court, come back to the state level, they then change their arguments and make their argument based upon the text of that state's constitution. So while they may have lost at the federal level, and so much so that it's changed the policy landscape nationwide, because a Supreme Court precedent changes precedent for the entire country, when they get back to their home states, they change their argument and they argue that state law is controlling in some way because it goes above and beyond the federal constitution.